All rise. The bailiff's voice echoed through Federal Courtroom 24 as Judge Richard Lyon entered with a stern, stormy look. Within legal circles, he was known as the Hammer, a judge feared for his tough questioning and absolute intolerance for unprepared lawyers. A single remark from him could end a career, but today, he seemed even more on edge than usual. "The Wilson voting rights case," he announced sharply, scanning the packed courtroom. "Let's not waste time." The state's attorney rose with confidence, anticipating an easy win. After all, the government rarely lost cases like this. Then, Jasmine Crockett stood. Few expected much from her. At just 38, she was about to argue her first major case before one of the most formidable judges in the country. Most observers believed she had no chance, neither against the state's legal team nor the uphill battle faced by the thousands of minority voters she represented. Crockett approached the podium, with only a single manila folder in hand. No team of paralegals, no stacks of case files, just that folder. The opposing counsel smirked, certain the outcome was already sealed. Judge Lyon's sharp eyes narrowed. Then, Crockett began to speak. The courtroom fell silent. The judge's expression changed instantly, his focus fixed entirely on her, as though she had revealed something no one had anticipated. The state's attorney stopped smiling. The audience began whispering in disbelief. "Your Honor," Crockett said firmly, pulling out a document from her folder. "Before we proceed, I'd like to present evidence that will completely alter our understanding of this case." What she revealed next would not only shake that courtroom, it had the potential to reshape voting rights law across the United States for years to come. If you want to know what was in that file and what left the Hammer speechless, make sure to hit the like button and subscribe, because what happened next stunned everyone. The Wilson versus State Election Board case began after new voter ID laws prevented nearly 200,000 citizens from voting in the previous election. On the surface, these laws appeared fair. Requiring government-issued photo IDs seemed reasonable to most Americans. But in certain targeted communities, DMV offices were closed, their hours reduced, or relocated far from public transport routes. For many, getting an ID now meant losing a day's wages, finding childcare, and traveling over 40 miles each way. The impact was devastating. In Westwood County, voter turnout dropped by 63% after the law was enacted. In predominantly minority neighborhoods like Eastern Heights, hundreds of longtime voters were turned away. Elderly citizens who had voted for decades were suddenly told their IDs were no longer valid. "I've voted in every election since 1964, said James Wilson, a 78-year-old veteran standing outside the courthouse. "I fought for this country, paid taxes all my life, and now they tell me my VA card doesn't count." That's not right. Wilson became the lead plaintiff after walking 3 miles to his polling place, only to be denied his ballot. Judge Richard Lyon was not. At 72, Judge Richard Lyon was far from an ordinary federal judge. In the legal world, he commanded both respect and a measure of fear. Appointed by President George W. Bush in 2002, Lyon had built a reputation for being fiercely independent and often unpredictable. He once ruled against the NSA's mass phone surveillance program, calling it almost Orwellian, yet upheld other highly contested policies. Lawyers entering his courtroom studied his past rulings obsessively, knowing he followed no political agenda, only precise legal reasoning. His clerks called him the Hammer for the way he dismantled weak arguments. One attorney once warned, "If you walk into Judge Lyon's courtroom unprepared, you might as well surrender the case." His exceptional recall of case law made bluffing impossible, and many lawyers had faced public embarrassment for trying. Across the courtroom stood Jasmine Crockett, a woman whose path to that moment had been anything but typical. Raised in South Detroit by a single mother who worked for the Postal Service, Crockett balanced multiple late-night jobs to put herself through school and law. Unlike the polished attorneys who often appeared in federal court, she built her career defending clients who couldn't afford costly representation. Before taking on this voting rights battle, she was already known for winning freedom for wrongfully convicted individuals. In one landmark case, she exposed buried police misconduct hidden deep within thousands of files, proving a man's innocence after 12 lost years. But what made this new case extraordinary wasn't just its legal importance, it was the David versus Goliath struggle happening in real time. The state's defense was a 6-member legal team from one of Washington's most prestigious firms, boasting over a century of combined courtroom experience. Their lead attorney, Bradley Thompson, had argued before the Supreme Court 7 times and never lost a voting rights case. His team filed a 378-page brief dissecting every argument Crockett made. By contrast, her own submission was just 42 pages long. What no one in that courtroom realized, however, was that Jasmine Crockett's strategy was unlike anything they'd seen before. While most civil rights lawyers relied on sweeping constitutional arguments and emotional appeals, she had spent 6 painstaking months constructing her case from the ground up, using a radically different approach that would soon leave everyone stunned. Crockett personally traveled to every community affected by the new law, gathering 358 first-hand accounts from voters who were denied the chance to cast their ballots. Using census data, she cross-referenced those stories with maps of DMV locations, exposing how the new regulations disproportionately hurt certain districts. But her strongest evidence came from thousands of internal emails obtained through Freedom of Information Act requests. For nearly 3 weeks straight, she worked 18-hour days in her small office, manually reviewing over 11,800 government documents. Deep in those files, she uncovered something no one, not even the state's attorneys, knew existed. That morning, the courtroom was packed. Civil rights leaders sat beside everyday citizens whose right to vote hung in the balance. The press section overflowed with national reporters, all sensing that this case could reshape voting rights laws in 17 other states. As Judge Lean entered and called the session to order, few could have imagined they were about to witness one of the most pivotal and intense legal battles in recent history. This was more than just another hearing. It was a fight that could redefine how American courts interpret voter access and equality for generations to come. Have you ever faced obstacles while trying to vote? Were polling stations easy to reach, or did you encounter long lines, confusing procedures, or limited access? Share your experience in the comments below. Real stories from real voters shed light on how deeply these laws affect everyday Americans. As the bailiff called for order once again, the air inside the courtroom felt electric. Rise. The United States District Court for the District of Columbia came to order. Presiding over the session was the Honorable Judge Richard Lyon. As he entered the courtroom, his black robe moved behind him with quiet authority, his eyes scanning the filled gallery. "You may be seated," he said in a deep, firm voice. "We're here today to hear oral arguments in Freedom Access Project versus Brennan Election Commission. Ms. Crockett, you may begin." Jasmine Crockett rose and approached the podium with calm assurance. The faint sound of her heels echoed across the marble floor as she placed a single binder in front of her, though she barely glanced at it. "Thank you. Your Honor," she began, her tone steady and confident. "This case raises a fundamental question. Can a state enforce voting rules that look neutral on paper but create clear discrimination in practice? The Supreme Court has long held that the right to vote is the foundation of all other rights. When that right is undermined, our democracy itself is weakened." She paused, meeting Judge Lyon's gaze. He leaned forward, listening closely. "The state argues these ID laws prevent voter fraud," she continued. "Yet, in the decade before these laws were passed, there were only 7 verified cases of in-person voter fraud out of over 14 million votes cast, a rate of just 0.005%. Judge Lyon interjected, as he often did. "Ms. Crockett, fraud prevention remains a legitimate state interest, no matter how rare the instances. The Supreme Court affirmed this in Crawford v. Marion County. At this point, many attorneys might become defensive, but Crockett didn't." "You're absolutely correct, Your Honor," she said firmly, catching him off guard. Crawford did uphold fraud prevention as a valid concern. However, that same ruling also established a balancing test, weighing the state's interests against the burden placed on voters. With that, she unfolded a large color-coded map. "With the court's permission, I'd like to display something," she said. The judge nodded. "The red areas," Crockett explained, "represent regions where over 30% of eligible voters lack the required photo ID. The blue dots mark DMV offices where those IDs can be obtained." Notice that in the darkest red areas, there are almost no blue dots. Judge Leon studied the map carefully, his brow tightening. "And your point, counselor?" he asked. "My point, Your Honor," Crockett replied, "is that for voters in these red zones, mostly minority communities, obtaining an ID can mean traveling up to 175 miles round trip. For many without cars, that's a 3-hour bus ride each way, assuming bus service even exists. The few DMV offices that serve these areas are open only 2 days a week, from 9 a.m. to 4 p.m., hours that make it nearly impossible for working people to go without losing income." The state's attorney, Michael Reynolds, stood abruptly. "Objection. Your Honor, the inconvenience of travel doesn't amount to a constitutional violation." Judge Leon turned to him sharply. "This is not a trial, counselor. You'll have your turn. Sit down." He looked back toward Crockett. "Please continue." Crockett gave a respectful nod and proceeded, her composed tone commanding the courtroom's attention. "Thank you, Your Honor," she said. "In Harper v. Virginia Board of Elections, the Supreme Court ruled that no state may impose any cost, direct or indirect, on the right to vote. While the state may not charge for the ID itself, our economic analysis shows the actual cost, including lost wages, transportation, and necessary documents like birth certificates, averages around $175 per voter." She built her argument steadily, layering each point with precision. Every potential counter-argument was anticipated and addressed before the judge could raise it. For nearly 40 minutes, Crockett moved seamlessly through complex areas of constitutional law, citing landmark precedents that spanned decades of voting rights cases. Judge Leon, known for his sharp questions and frequent interruptions, found himself unusually quiet, listening rather than challenging. When he did pose a question, Crockett responded with clarity and confidence, reflecting both preparation and deep understanding. Everyone in the courtroom sensed it. Something exceptional was happening. Then, the question came that would shift the course of the hearing. The judge leaned forward. "Ms. Crockett," he said, "let's consider a hypothetical. Suppose the state assigns polling stations based on the last 4 digits of a citizen's social security number. If this rule seems neutral but results in minority voters traveling twice as far as others, with no proof of intent to discriminate, would that violate the Constitution?" The room fell silent. It was the kind of hypothetical that had trapped many lawyers before. Crockett paused briefly, gathering her thoughts. "Your Honor," she replied calmly, "that scenario closely resembles the reasoning in Gillian v. Lightfoot. In that case, a city redrew its boundaries in a way that excluded 99% of black voters, without ever mentioning race in the statute. The court still struck it down, recognizing that a law can appear neutral, yet still produce a discriminatory effect." She took a measured breath, then pivoted seamlessly into her next point. ChatGPT said, "And Your Honor, your hypothetical underscores a crucial point in this case. The state's argument essentially suggests that as long as race isn't explicitly mentioned, any level of disparate impact is acceptable. That reasoning directly conflicts with both precedent and principle." Then came an unexpected turn. "May I approach the bench again?" she asked. Judge Leon, clearly intrigued, gave a nod of approval. Crockett retrieved a printed email chain from her table and handed copies to the judge and opposing counsel. "This," she began, "is an internal communication between the state's election commissioner and the consultant who helped draft these ID rules. Please refer to page 3. A quiet murmur spread through the courtroom as the judge began reading. The consultant had written, "The beauty of using these specific criteria is that they disproportionately affect demographic group A, while giving us full deniability since race is never mentioned outright." A ripple of shock passed through the gallery. Judge Leon's eyebrows lifted slightly. "And how did you obtain this document, Ms. Crockett?" he asked. "Through standard discovery procedures, Your Honor," she replied calmly. "It was part of the 50,000 documents submitted by the state. I suspect they didn't realize it was included. It was hidden deep within a section labeled Database Technical Appendices." Across the aisle, the state's attorney, Michael Reynolds, flipped rapidly through his copy, his face paling as he found the incriminating line. "This case," Crockett continued firmly, "is not just about disparate impact, it's about deliberate discrimination masked as neutrality. The Supreme Court's Arlington Heights framework exists precisely to uncover this kind of concealed bias." The entire courtroom seemed to shift. What had started as a routine constitutional hearing now felt like a defining moment in real time. The audience leaned forward. Even the clerk appeared captivated. Judge Leon reread the email more slowly this time, his expression tightening as he considered its implications. For several seconds, the only sound was the soft hum of the air conditioning. Finally, he looked up, his tone deliberate. "Ms. Crockett," he said, "you've presented substantial evidence suggesting intent. But even assuming discriminatory purpose, the state maintains that its regulations pass strict scrutiny because preventing voter fraud is a compelling governmental interest." The tension in the room thickened. This was the critical moment of her argument. All eyes turned to Jasmine Crockett. She paused briefly, then spoke with calm conviction. "Your Honor, for any law to withstand strict scrutiny, it must be narrowly tailored to serve a compelling interest. These ID laws fail that test for 3 clear reasons." She raised one finger. "First, they are not narrowly tailored. Our data shows that 94% of the burden falls on minority communities to address a problem, in-person voter fraud, that statistically does not exist." A second finger. "Second, there are at least 16 less restrictive alternatives that could achieve the same anti-fraud goal without disenfranchising lawful voters. Those options are outlined in our brief," a third finger. "And finally, the newly uncovered email proves that fraud prevention was never the true motive. When the justification is pretextual, strict scrutiny cannot be met." Then came the moment that would dominate headlines for weeks. "Your Honor," she began, her tone calm yet firm. "With the court's permission, I'd like to present one final piece of evidence, obtained just yesterday." Judge Lean gave a measured nod. Crockett handed a sealed envelope to the clerk, who then delivered it to the bench. As the judge broke the seal and unfolded the document, his expression shifted, curiosity fading into disbelief. Inside was a confidential memorandum from the state's own election security division, dated only 2 weeks before the new voter ID law was announced. The document read clearly, "After a thorough review, we find no evidence that in-person voter impersonation poses any significant threat to election integrity." A collective gasp rippled across the courtroom. Even Judge Lean's typically stoic face revealed genuine surprise. The report continued, urging that resources be directed toward addressing actual vulnerabilities, particularly in cybersecurity. Judge Lean looked up, eyes widening. This directly contradicts the state's central argument for enacting these regulations. "Yes, Your Honor," Crockett responded steadily. "The Commission disregarded its own experts' findings because the real purpose behind these laws was never to prevent fraud." At once, the state's attorney, Michael Reynolds, rose to his feet. "Your Honor, we've never seen this document before. We object to its late submission." Judge Lean's gaze sharpened. "Mr. Reynolds, this appears to be an internal memorandum from your client's own department. Are you implying the Commission withheld this during discovery?" Reynolds hesitated. "I would need to verify that with my client." "I suggest you do that immediately," the judge replied coldly. "This court takes discovery obligations very seriously." Turning back to Crockett, Judge Lean studied her carefully. The courtroom fell silent. Everyone sensed something extraordinary was happening. Known for his composure, Judge Lean now appeared visibly moved. "Ms. Crockett," he said, his voice resonating through the chamber. "In my 30 years on this bench, I've rarely witnessed reasoning of this caliber. You've just redefined how this case must be interpreted." The courtroom stirred with murmurs. Later, legal analysts would remark they had never heard Judge Lean deliver such open praise in session. Yet what followed was even more remarkable. Instead of embracing the compliment, Crockett spoke with quiet conviction. "Thank you, Your Honor. But this case isn't about personal skill or recognition. It's about the constitutional right of every citizen to vote freely, without man-made barriers that silence their voices. The 150,000 Americans who have effectively lost that right deserve this court's protection far more than I deserve." Acknowledgement. Her words redirected. attention from herself to the broader principle at stake. Several spectators nodded in silent agreement. Judge Lean leaned back, a faint smile crossing his face. "Well said, Counselor. Well said indeed." Turning to the state's attorney, he continued, "Mr. Reynolds, it appears you have some serious work ahead of you. Proceed." Reynolds stepped to the podium, visibly shaken. His earlier confidence had evaporated as he shuffled through his notes. "Your Honor," he began, voice unsteady, "while Ms. Crockett's remarks were certainly compelling, she misrepresents the state's position and the applicable law." But his argument quickly faltered. Judge Lehan interrupted several times with pointed questions. "Mr. Reynolds, how do you defend your fraud prevention claim when your own security team concluded that in-person fraud is almost non-existent? How do you justify the internal email discussing how to target specific demographic groups under the guise of neutral criteria? And with only 0.005% of votes showing any sign of fraud, how can this regulation, which impacts 17% of eligible voters, be considered narrowly tailored?" Reynolds struggled to respond. By the time he finished, the courtroom sensed the outcome. When Jasmine Crockett stood for her brief rebuttal, her calm but steady voice filled the room. "Your Honor, this case isn't about complex legal theory. It's about whether the Constitution allows the government to make voting harder for some than for others. The evidence and proceedings make the answer clear. It does not." As she gathered her papers and sat down, silence filled the courtroom. Everyone knew they had witnessed something historic, not just exceptional advocacy, but a defining moment in the fight for voting rights. When Crockett exited the courthouse, reporters and cameras surrounded her. "Ms. Crockett, what's your reaction to Judge Lehan's remarkable remarks?" one journalist asked. She paused thoughtfully. "What matters isn't praise for me. What matters is whether the court defends the rights of voters silenced by these unfair laws. This case has always been about them." Her response quickly went viral, earning widespread respect for keeping the focus on justice rather than personal recognition. Behind closed doors, the state's legal team scrambled. Reports surfaced of emergency meetings to consider a possible settlement before Judge Lehan could issue what many believed would be a devastating ruling. Legal experts across political lines agreed that what happened in that courtroom had changed everything. Harvard law professor Lawrence Tribe posted, "What Jasmine Crockett achieved today wasn't just skilled advocacy. It was a masterclass in constitutional law that future lawyers will study." Even conservative scholars acknowledged the strength of her performance. Former Solicitor General Paul Clement remarked on a legal podcast, "Regardless of politics, the level of advocacy Ms. Crockett displayed was extraordinary. She dismantled the state's case piece by piece with precision and evidence." 3 weeks later, Judge Lehan released his ruling, an 87-page opinion granting a preliminary injunction that blocked the controversial voting regulations. His opening lines were unusually direct. "This case is a textbook example of regulations that, while neutral on paper, were intentionally designed to limit the voting rights of minority citizens. The evidence of discriminatory intent is overwhelming, and the state's justifications cannot survive constitutional review." Judge Lehan's decision reshaped how courts assess election laws that disproportionately affect minority communities. He wrote that when voting rules place heavier burdens on certain groups, judges must look beyond official explanations. Internal communications, data showing unequal impact, or contradictions between public and private statements can all expose unconstitutional intent, even without racial wording. The decision sent shockwaves nationwide. Within days, 5 states announced reviews of similar laws. Voting rights organizations in over a dozen states filed new challenges citing Judge Lehan's opinion as persuasive precedent. For thousands of voters, the effects were immediate. The state was ordered to suspend its strict ID rules and implement a fairer system, ensuring equal access to the ballot box. In the following election, voter turnout in previously restricted areas rose by 31%. 2 months later, Jasmine Crockett was invited to deliver the keynote address at the American Bar Association's annual Civil Rights Conference. Her speech, "Constitutional Advocacy in the Modern Era," became required viewing in law schools across the country. "The Constitution's promises don't fulfill themselves," she told the packed audience. They depend on advocates who connect abstract principles with real lives. When we let technicalities outweigh basic rights, we fail the very document we claim to honor. Her closing line would be quoted by generations of lawyers. The strongest weapon in constitutional advocacy isn't eloquence or ideology, it's preparation. The quiet discipline of mastering facts, studying precedent, and anticipating every counter-argument before stepping into court. That unseen effort becomes real power when the time comes to defend someone's rights. Perhaps the most meaningful praise came from Judge Leon himself. In a rare interview with Legal Times, he reflected, "Judges are guided by law and facts alone, but sometimes an advocate presents them with such clarity that it deepens your understanding of the Constitution itself." Ms. Crockett's case was one of those moments. The ruling's greatest impact wasn't in Washington but across the nation. In the years following Judge Leon's opinion, states were forced to revisit voting procedures that unfairly hindered minority, elderly, and disabled voters. Access to the ballot expanded, participation rose, and democracy became more inclusive. Law schools now teach Crockett's case alongside landmark voting rights precedents, and constitutional law textbooks include excerpts from her arguments and the court's ruling. A new generation of lawyers studies Crockett's approach, her precision, calmness, and mastery of both principle and law. For Jasmine Crockett, the case became both a defining moment and a launchpad for broader impact. She continued her advocacy for civil rights, focusing on voting access, criminal justice reform, and economic equity, while staying connected to the communities she served. When a journalist later asked if she viewed herself as a legal celebrity, Crockett smiled. "No," she said. "I see myself as someone doing necessary work. Millions of Americans still face barriers to their rights. My role is to use my skills to protect them." The lesson from that unforgettable courtroom day was never about fame or applause. It was about the quiet strength of preparation, the courage of moral conviction, and the enduring power of principle in action. One person, armed with knowledge and purpose, can still reshape law and history itself. For those who witnessed that moment, the memory remains vivid. A silent courtroom, a brilliant advocate, a moved judge, and the Constitution defended with clarity and grace. For the thousands whose voting rights were restored, the legacy endures. The simple, powerful ability to stand as equal participants in American democracy. If this story of courage and advocacy inspired you, don't forget to like this video and subscribe to our channel. We share powerful courtroom moments that shape the fight for justice and protect the future of constitutional rights. Share this story with anyone who believes that preparation and principle still matter in the pursuit of truth.